I may be permitted to make one submission, my lords. I may be permitted to make one submission. My lords, in fact, earlier did mention that my lords will not be hearing too many interveners or impleaders. I'm aware my lords mentioned
No,
it.
we have not said this. We have said we will, after hearing the petitioner and respondent, then we will decide whether we require the assistance
I'm
of
grateful. My lords, that's all. I seek the permission. I filed an impediment or intervener application to raise grounds of discrimination which have not been covered. We will not seek to repeat anything which has been covered. The other councils have covered it. My lords, I request the indulgence of my lords if after the respondent.
If we will permit anyone, then we will permit everyone and every intervener applicant to argue. But right now, we don't feel that we require any intervener. So let us wait.
Please, my lords.
Wait,
Wait for my lords.
Arguments of petitioner and respondent finish, then we'll see whether we require the assistance of interveners or not.
Grateful, my lords. I take that chance.
My lords,
1.6. I filed a memo with all
He is in the middle of
complete my
he is in the mid of his argument.
Yes.
Let him finish his argument, then we will.
But on the previous occasion, but I have made my submission with reference to the government order dated 5/2/2022. The second issue which my lords were in the midst of hearing was on the question, lords, as to whether the practice of hijab can be elevated to the status of a fundamental right under Article 25 of the Constitution. Submission, of course, lords, is that it does not partake.
You have finished on that government order.
We have finished work on the government order dated 5/2/2022.
We will like to have one clarification
Yes.
on that itself.
Yes.
You have argued on that government order that it is totally innocuous. You have not issued any direction restricting the wearing of hijab. This is what probably is your stand, that the state government has not put any restriction and this government order does not say anything about wearing of hijab. It only says that the uniforms which have been prescribed in the schools and the pre-university colleges shall be worn. This is your stand. Now, please come to paragraph 19 and 20 of your statement of objection. Now kindly read this.
I'll read. It is pertinent, para 19. It is pertinent to note that the government of Karnataka exercising its powers under section 71I, 72G5, read with section 133 of the Karnataka Education Act 1983 and Rule 11 of the Karnataka Education, Classification, Regulation, Description of Curricula, etc., Rules 1995, has issued government order dated 4/2, has to be 5/2,
Yes.
5/2/2022, regarding uniform policy for the educational institution in the state. The said notification has been issued having regard to the conflicting views, demands by various educational institutions and students at large. After raising of the issues involved in these petitions, the students of various institutions of the state of Karnataka have started insisting of clothes to be worn of their choice, and they are seeking for relaxation and exemption from following uniform dress code prescribed by various institutions governed under the Act. In order to resolve the controversy, the government thought it appropriate to prescribe uniform dress code by virtue of the order dated 5/2. It has to be read as 5/2/2022. Copy of the order dated 5/2/2022 is Annexure R8. In order to maintain public order to provide equal treatment to all students and to avoid unnecessary controversy in the college and campus of educational institution in the state, to maintain secularism among students of the above clarification has been issued, making the prescription of uniform dress code clear to all students.
Now,
Yes.
what is the import of this saying that you are saying that the uniform is to be followed in the institutions?
Yes.
And what is your stand whether the hijab can be permitted in the institutions or not?
But in the government order, which is impugned before your lordships, dated 5/2/2022,
Yes.
the operative portion leaves it to the discretion of each of the.
If suppose the institutions permit,
Yes.
then you do not have any objection?
But if the institutions are to permit hijab or prohibit hijab, both of them, it is possible.
Yes.
But we would possibly take a decision as and when that situation would arise. The reason is this.
No, you have to make your stand very clear.
Insofar as we are concerned, on the second issue as to whether hijab is a part of a fundamental right, but we have said no, according to us, no, and I'll substantiate before your lordships. But I was merely explaining before your lordships. But now the petitioners came before your lordships and assailed the order dated 5/2.
It has been argued by the petitioners
Yes.
that they may be permitted to wear the same color which is prescribed in the uniform as a headdress
Yes.
in the institutions. Now, if therefore we want that, what is the stand of the state government on that? Whether that can be treated to be part of the uniform or not. The second thing is that it was also argued by Mr. Sanjay Hegde that if suppose they are wearing dupatta, which is part of the uniform, and that they wear it over the head also, that whether that can be permitted or not.
But may I not make this stand of the state clear in this issue? Petition, of course, these are all sub-issues which have been raised. Broadly, the assailment was of the order dated 5/2/2022. On various grounds, as I suggested, creation of college development council. It is irrational. It intends to prevent members of the particular community from wearing religious marks. But in answer to that proposition, I had submitted before your lordships that the order dated 5/2/2022, if read as it is, that is the operative portion, it gives complete autonomy to the institution to prescribe the dress of the. Now, the question as to whether students should be permitted to wear dress of one or the other, the answer would go back to the same. But not as a matter of principle as to whether really students must be allowed to wear dress or any apparels, or that which will be symbolic of religious this one. The answer seems to be For instance, the preamble of the Karnataka education itself says that we propose to foster a secular outlook among all students. And now, Lord, therefore, Lord, my submission before your lordships, when the lordships deal with the second issue, lordships would see the whole object, Lord, particularly in educational institutions, or for that matter, any other institutions, the element of introducing a religious aspect should not be there. That is the stand of the state.
If you are wearing that part of the uniform over your head, how it will be in any manner would be a religious thing?
But these are aspects, but the broad stand of the state. But now, if I have to say so much, anything which would depict religious aspect, but now that would become very difficult. Nitpicking off on each aspect, it would go into very specific spots as to what part should be considered religious, what should not be considered religious. These are what matters. My respectful submission to lordships is to leave it to the discretion of the institutions concerned.
Your stand is that the state government is not interfering.
Yes.
It is left it to the institutions to decide as to whether they have to permit hijab or not.
No.
This is your
Yes, that is our stand. Larger issue as to whether hijab,
whether we are required to go into all these constitutional questions which have arisen.
No, now that
whether it is an essential religious practice or not, whether it amounts to violation of Article 25(1), or
no, I will explain.
Whether it is required to be seen by us.
No, but according to me,
this is the stand of the state government.
According to me, it may become necessary for this reason. But broadly, if lordships are, let us say this institution was before your lordships, and if this allegation was made against that they are preventing me from wearing hijab, the institution possibly, and now
can we restrict the institutions? Can we restrict the institutions? State government can do that. We can put that issue directions, but whether they are amenable to the court. These institutions, they are private bodies.
But the petitioners, yes.
The college committees,
yes.
All that. They are. You say that they have to decide now.
They have to decide
whether are we supposed to see what they have done it.
No, may I explain where the difficulty would come, or where the difficulty has arisen now in the present circumstances is this.
Not the statutory bodies.
I'll explain what is the difficulty.
Constituted, as you say, in order to give effect to the Rule 11.
Yes.
These committees, this is what you argued. They are not actually not the statutory bodies. They have been created under your circular.
Yes.
So, in order to give effect to Rule 11.
Yes.
Now, since they are not statutory bodies, can they be regulated by the court order?
But may I explain, lordships? But that aspect has to ultimately, these institute. Let us say,
do you understand?
No, I understand the query of the court, and I'll answer.
Because the stand of the state government is that they are not interfering.
Yes.
They are not saying whether hijab is to be worn or not.
Institutions, schools, colleges, etc. Yes.
Institutions.
Yes.
So now argue on this.
No, I will. May I put it across in this manner? There the difficulty would come, and why this issue number 10(2) requires to be answered by your lordships. Now let us say this institution is before your lordships. One of the questions which would be posed is: could you prevent a person from entering the institution wearing hijab? The answer would be to maintain institutional discipline. I am entitled to enforce that discipline by making certain restrictions. The petitioners would then contend that whatever be your internal rule, that cannot be enforced against us because I hold a fundamental right under Article 25. And any institutional discipline, which is by way of a bylaw or a rule, cannot be imposed upon us under Article 25. Therefore, my lord, this question as to whether hijab would form part of fundamental right under Article 25 requires to be decided. If let us say, lordships are to decide that wearing of hijab forms part of Article 25, then the question of any of the institutions, of course, subject to public order, once they pass those tests, assuming they pass those tests, then they cannot impose restrictions. If lordships are to then what decide, assuming that it does not form part of Article 20, then what different considerations would arise. Vis-a-vis the entire controversy revolves around this question as to whether it forms part of Article 25 or not. Because the immediate answer of every institution, not only this one, would be that to maintain internal discipline, regulations, but we have restricted them. The question of what they insisting on wearing something particular does not. And in this case, of course, the institution has taken a stand. For instance, the Udupi Pre-University College has passed a resolution, though not called into question, of course. They have taken a stand that yes, we will not permit hijab. About, of course, not exercise of writ jurisdiction against these institutions, but different character, different situations would arise. There are some government institutions which are amenable to writ jurisdiction. Even private educational institutions after TMA Pi Foundation, there's a number of private educational institutions conducting public. Yeah, therefore, we have many judgments. So that is something that is an area. But this issue, my lords may have to go into it. Therefore, lords, all that I was submitting before your lordship is 5/2/2022, we do not decide it. The reason is this, lords, and if I have to say so, Shirur-Mat onwards, the law seems to have evolved that as to what forms the religious doctrine of any particular religion must be decided within the preamble, within the zone of that religion itself. And the state, unless it is a secular activity, should not intervene. This seems to be broadly the law which seems to have developed. So today, Lord, if I have to take a decision, if I have to say this, and hold Lord's discussion and come to the conclusion that we will not permit hijab to be worn by any of the students because of various reasons, but that would have been seriously challenged before your lordships on the ground that the state has intervened in religious matters. But I will now show before your lordship, that is the preparation we had made, the Shabarimala Lord's judgment, where Lordship Justice Chandrachud for the first time says, the court in the modern constitutional jurisprudence assumes a central role in these matters. In a substantial dilution of earlier judgments, he says it is the constitutional court ultimately which has to decide as to whether the religious practice which is sought to be enforced under Article 25 will be enforced at all or not. And then the question of whether it's an essential religious. So this issue, but the government order, therefore, what I was submitting before your lordship, the government order is innocuous and it is consciously innocuous. I am very responsible. They are very consciously innocuous. Some of the institutions have taken a stand that they do not permit it. Some of the institutions they permit it. But this question was just whether the controversy would not have arisen at all if the petitioners had simply come before your lordships and said, all right, this institution is not permitting us to wear this hijab, permit us to wear, that the action is arbitrary, etc. They did not stop it. They did not ask your lordships, or rather request your lordships, that permit us to wear this headscarf as a dress. They say, permit us to wear this headscarf as a religious symbol. Now the question is whether it is a religious symbol, but it is part of as a religious practice. The question is whether it is part of religious practice necessarily may have to be decided. Once this controversy is settled, then other issues may follow. Then the question would be whether the institution would, what is the right of a student to enter an institution, to wear anything, not with reference to as a religious practice, right, by their own choice, but those are different considerations, Article 19(2) considerations. Principles of administrative law considerations will be.
I just want to check whether essential religious practice is also applicable to conscience, practice of conscience.
Yes. But the concept of a freedom of conscience, I have tried to explain the other thing, is something which relates to belief or non-belief. What you manifest your conscience relates to results in a religious practice. But in fact, Lordship Justice Dikshit also asked about the assembly debates. In this very question was raised as to how do we interpret freedom of conscience. But I'll just point out before Lordship how one of the freedom of conscience is something which you believe or do not believe, in simple. What you practice then becomes part of religious practice. The question of essential religious practice would possibly not come within the concept of freedom of conscience.
What my sister was asking was, it appears like this.
Yes.
Honorable Chief Justice had shown to you other day. It has two components. One is conscience. Conscience debates we will find in the assembly debate. Just Mr. K.T. Shah, a scientist, had raised that issue. And K.M. Munshi was also against it. Then Dr. Ambedkar suggested, along with Alladi Krishna Swami Iyer, no, there should be conscience also, because there may be persons who do not
Believe in
religion, believe in the existence of God, like Charvakas, among agnostics. They don't believe in the existence of God. Darwin.
Then whether they would be entitled to get the benefit or not. Therefore,
that is the question.
The word conscience has been put in the constitution.
I submitted that before.
Yes.
Of course, Justice Dikshit asked then at that point whether it would only be confined to atheists. That not necessarily is our answer, but I would submit before your Lordship's, and I'm in respectful agreement with the Lordship's observation, that freedom of conscience be construed as something what you believe in or not believe in. And if you put it in practice, it becomes practice of religion. I'll just point out that sentence. Which has
conscience and religion are two different
aspects.
Yes.
No, different plus mutually exclusive also that way.
And that has been considered also.
Yes. But I'll just point out how this was explained in the Constitution Assembly debates. It's a very short sentence, but I'll just point out. But may I draw, Lordships, in that book, page 821. In that collect 821.
Yes.
I don't think it's that.
821, yes.
I have no objection.
But this is what Honorable Shri Ghanshyam Singh, I'll just pass on. I'll just read this and pass on. I don't think that is given to Lordships. Honorable Shri Ghanshyam Singh Gupta says, Article 19, sir, is very comprehensive. It says all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. Now, as to freedom of conscience, it means that a man is free either to have a religion or no religion. If a man has a religion, then he is free to profess whatever religion he likes, either Islam or Hinduism or Buddhism or Sikhism and so on. Then professing that religion is free to practice the, Lordships get it? Or am I reading that statement? He is free to practice the dictates of that religion. For instance, if Islam requires that there should be namaz, a Muslim is free to practice it. and also to propagate it. What I humbly submit is this: the wearing of kirpan may be appropriately be called the practice of religion and the profession of Sikh religion. That's all I have to say. But what it seems to suggest is, it means either free to have a religion or no religion. That is the concept of conscience. Then the question of practicing that does not arise. But there's two comments that would read this along with what D.D. Basu says, where he says either to believe or not to believe. What you manifest is practice of religion. When you do not manifest it, insofar as persons who believe in something, persons who do not believe in anything, something, that question doesn't arise. But Dr. Ambedkar said something. Dr. Ambedkar, in a different context, the question was, why do you insist on having this right to propagate the religion? That is not, this is what Dr. Ambedkar says. So in that, in this, can I draw Lordship's attention to last page, not 884. So this was in the context of Article 28. No religious instructions will be imposed in any educational. That in that context, but there is some understanding what we can get it from this. But this is in the context of why we should not have a page 884. The third thing which I would like to mention in this connection is that, unfortunately, the religions which prevail in this religions which prevail in this country are not merely non-social. So far as the mutual relations are concerned, they are anti-social. One religion claiming that its teachings constitute the only right path for salvation, that all religions are wrong. The Muslims believe that anyone who does not believe in dogma of Islam is a fakir, not entitled to brotherly treatment with the Muslims. The Christians have a similar belief. In view of this, it seems to me that we should considerably disturbing the peaceful atmosphere and of an institution. These controversies with regard to the truthful character of any particular religion and the erroneous character of the other were brought into juxtaposition in the school itself. I therefore say that in laying down in Article 22(1), that in state institutions there shall be no religious instructions, we have in my judgment traveled in path of complete safety. 22(1) is the present day 28.
Draft is 22.
Yeah, draft is 22. 28 is, this was in the context, but I wanted to read in the context of why consciously they wanted to keep religious instructions outside the, let's say, educational institution, but to close down on Lordship's query that what is the difference between freedom of conscience with reference to right to practice of religion. As I have understood, and as could be seen, it seems it fundamentally applies to persons who do not believe in something or who believe in something and do not practice it. There is one other reasoning which could be adopted was, if freedom of conscience was not there and only right to propagate religion was there, the founding fathers possibly felt that that could result in imposition of religious beliefs by persons who practice some religion upon persons who do not believe that. In fact, there is one, I will find it and place it before your Lordship. But that debate does occur during the framing of the Constitution. Why freedom of conscience? But in fact, what's that? Lot of apprehensions. Lot of apprehensions were exhibited by a number of the members at that time. In fact, what some of the persons like K. Munshi and others expressed that if we are to adopt ourselves as a secular state, that may result in fact, there are a lot of discussion, that may result in some religion placing their hegemony over others, except that discussion. But they reach a consensus and say that we will therefore control it in this manner, subject to public order, morality, and health. Then we will allow the state to intervene in financial, political, secular matters. We will subclause, interestingly in this one, subclause 225(2)(b, Lordship Service, which provides social reform and throwing open of Hindu temples, to members of all class was originally not there. In fact, Dr. Ambedkar constituted a subcommittee consisting of Sardar Vallabhbhai Patel and Shyama Prasad Mukherjee. It was they who said that no, we should introduce the concept of social reform to all religions. That is interesting. The first paragraph of 25(2)(b) is social reform to all religions, throwing open of temples only to Hindu temples. The prevailing circumstances at that point. But I must say, in this regard,
the secularism which the makers of our constitution conceived in is not akin to the secularism of American constitution. Ours oscillates between Sarva Dharma Samabhava on the one end and Dharma Nirapekshata on the other. We oscillate between these two. It's not a wall between church and the government.
It is not a wall between them. That is true. Like S.R. Bommai versus Indian of but I have that. They say
Concept of secularism
has been very nice.
That was in the light of electoral law.
Electoral, of course, but
many aspects are there.
Other aspect of this one. But now that lordships are in this, but I'll just complete reading this constitutional before I go into that next. Now that lordships have that, the relevant, but we did not, Lords, I must say, Article 20. In the context of the present controversy, there is not much discussion, except what this very telling statement by Dr. Ambedkar, saying that do not allow religion to come within the institution in this context, because every religion has a different percepts. There is a likelihood of a clash within the institutions. Therefore, let us keep religious instructions consciously outside the institution. So what they actually meant was not religious instruction, religion itself, not outside. It is not that what Bhagavad Gita, Quran, or the Bible has anything, but all of them have noble thoughts. But there was a likelihood of a discord or a clash, which they felt should be consciously kept out. That is one paragraph what I wanted to bring to Lordship's notice in the context of the present controversy, which relates to carrying religious symbols within the institution. That is one thing Lordships may kindly keep.
Supreme Court also has said many
Yes.
times. 2017 also they have said that religion has to be kept out of institutions.
Education. Ayesha Ranjan's case. Right? But sir, I do not want to trouble your lordships again with this one other paragraph. I just want to read it and leave it at that.
But our constitution did not enact what Karl Marx had said, religion is opium of masses. We did not enact here.
But I think towards one of the most delicate subjects, the Constitutional Assembly, the makers dealt it. And therefore, I can draw the conclusion in this manner. Freedom of conscience has been used in contradistinction to practice of religion. I do not want to say it is only meant for non-believers. I want to maintain that it also applies to believers. If the believers practice that belief, it turns out to right to practice of religion. If they do not do so, it relates to freedom.
In other words,
Yes.
what you want to say is, unless the conscience gets manifested
Action.
by some overt act of the practitioner,
Absolutely.
till then it remains within the
Yes.
parameters of conscience.
Yes.
Once there is overt act,
Yes.
then it transcends that and comes to religion.
Religion, exactly. Therefore, the word freedom of conscience and right to practice. The word freedom and right have been very consciously used. Freedom is what you have within you. When you want to exercise it, that becomes a right against others. Therefore, that word, they did not say right to conscience and right to religion. They said freedom of conscience. But the second issue which I wanted to bring to Lordship's notice was on the question about elevating this right to wear hijab, Lords, as a fundamental right under Article 25. But I must straight away take Lordships to Article 25. I have taken the Lordships note. I must straight away bring to Lordships notice that the law in regard to essential religious practice seems to be almost authoritatively settled by the Honorable Supreme. But I'll explain it in this manner. But interestingly, if Lordships are to see 25, it does not speak of essentially religious practice. It speaks of protection for religious practice. The question was possibly which arose at that time, in the initial years of the evolution of law by the Honorable Supreme Court was, religion itself is incapable of a precise definition. It has many tenets, observances, rituals, dress, food, etc. That is how in Shirur Math's case, their Lordships define religion. It is impossible to define what exactly is a religion. And particularly among Hindu community, that's what they say, with multi-faiths and different situations, it became impossible. Therefore, they evolved this theory, and I will show before you that what Article 25 protects is not practice of religion, but practice of essential religious practice. They narrowed it to what is essential. But the first of the judgments with the Honorable Supreme, there are 4 judgments I will cite, and the journey from Shirur Math to Shabarimala, wherein first time they used the word essentially religious. That is, what practice which is religious becomes essential. 2, in Shabarimala they said it should be essential to religion. This is what their Lordship finally come to them. His Lordship Justice Chandrachud makes that fine distinction and says, but I will show it before you. Initially, Shirur Math took the stand that what is religious or essentially religious becomes protected under Article 25. Then Lords Venkataswamy Devaru onwards, the law altered, and finally in Shabarimala they declare, you have to show for the purposes of getting protection under Article 25 that the practice which you want protection should be not just religious, but essential to religion.
That is the crux. That is the crux.
That is the crux. And 4 tests, that I will show. Kindly see.
But before this, we must understand what amounts to essential.
Essential. That is also there. But that fortunately, that's what in Avadhuta's case, and Shabarimala was fantastically expounded. They in fact give 5 tests. You apply these 5 tests to the present formula, see what solution comes out of it. If it is essentially to religion, declare it as essential. If it is not so, then it's not. But there are 5 instances. 5 instances, under Islamic law, they came and said essentially religious practice. Supreme Court turned down. 7 instances of Hindu law, when they came down, Supreme Court turned down. I have all those. In every such situation, they have applied this test of principle. But may I draw lots of attention to
where is that judgment?
Yes, straight away I am coming.
Yes.
4 judgments, but I'll just show the evolution. Dargah case, Lordships, my first kindly to Ajmer, AIR 1961, SC 1402, volume 1 words of that compilation, page 121.
Even SC?
I'll just give the citation. AIR 1961, Supreme Court 1402. Dargah Committee, Ajmer and another versus Syed Hussain Ali and others.
We got a compilation.
Yes, yes, it is there. Where is that? Page 120. The judgment starts from page 121. What is relevant is at page 133, paragraph 33. This was a case where an act was brought about by the UP legislature, taking away the traditional Sufi followers from collecting the tasdeeq or contribution made to the Dargah. That was challenged on the ground that it takes away the essential religious practice. 33 clauses.
33.
Yes, sir. At page 133. We will first take the argument about the infringement of fundamental rights to freedom of religion. Article 25 and 26 together safeguards the citizens' right to freedom of religion. Under Article 25(1), subject to public order, morality and health, and to the other provisions of Part 3, all persons are equally entitled to freedom of conscience and their right freely to profess, practice, and propagate religion. This freedom guarantees to every citizen not only the right to entertain such religious beliefs as may appeal to his conscience, but also affords him the right to exhibit the belief in his conduct by such outward acts as may appear to him proper in order to spread these ideas for the benefits of others. Article 26 provides that subject to public order, morality and health, every religious domination of any section thereof shall have the right. My lords have skipped that one, not be necessary. Lordships are aware. The 4 clauses of this article constitute the fundamental freedom guaranteed to every religious domination of any section thereof to manage its own affairs. It is entitled to establish institutions for religious purposes. It is entitled to manage its own affairs in the matters of religion. It is entitled to own and acquire movable and immovable property and to administer such property in accordance with law. What the expression religious denomination means has been considered by this court in Commissioner Hindu Religious Endowment Madras versus Sri Lakshminendra Tirthi Swamiyar of Shirur Math. Mukherjee, as he then was, who spoke for the court, has quoted with approval the dictionary meaning of the word denomination, which says that a denomination is a collection of individuals classed together under the same name, a religious sect or a body having common faith and organization, and designated by a distinct name. Learned judge has added that Article 26 contemplates not merely a religious domination, but also a section thereof. Dealing with, this is important, dealing with the question as to what are the matters of religion, the learned judge observed that the word religion has not been defined in the Constitution, and it is a term which is hardly susceptible of any rigid definition. Religion, according to him, is a matter of faith with individuals or communities, and it is not necessarily theistic. It undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as a conducive to their spiritual well-being. But it is not correct to say that religion is nothing else but a doctrine of belief. A religion may not only lay down a code of ethical rules for its followers to accept. It might prescribe rituals and observance, ceremonies and modes of worship, which are regarded as integral parts of religion. And these forms and observances might extend even to matters of food and dress. Dealing with the same topic, though in another context, Venkatramana Devaru versus State of Mysore, Venkatram and I spoke for the court in the same way and observed it was settled the matters of religion in Article 26b, includes 7 practices which are regarded by the community as part of the religion. And in support of the statement, the learned judge referred to the observation of Mukherjee. We have already cited. But this is the sentence which we are relying upon, this paragraph. While we are dealing with this point, it may not be out of place incidentally to strike a note of caution and observe that in order that the practices in question should be treated as part of religion, they must be regarded by the said religion as its essential and integral part. Otherwise, even purely secular practices, which are not an essential or an integral part of religion, are apt to be clothed with religious forms and may make a claim for being treated as religious practices within the meaning of Article 26. Similarly, even practices, though religious, may have sprung from merely superstitious beliefs and may in that sense be extraneous and unessential accretions to religion itself, unless such practices are found to be constitute an essential and integral part of a religion, their claim for the protection under Article 26, 25 also same principle, may have to be carefully scrutinized. In other words, the protection must be confined to such religious practices as are an essential and an integral part of it and no other. This has now been expanded straight away. Volume 2, page 428. Javed. This is a very volume 2, page 428. This was a case, where Haryana government legislature had brought in a legislation for that persons with more than one marriage shall be disqualified from contesting elections. The plea was that Islam permits marriage on more than one occasion. Therefore, treat it as part of Article 25. May I draw that? This is the background. Can we see how the lordships deal with this? The plea was
2004.
2003 Part 8 notes SCC.
2004 12 SCC.
It starts from
2004 12 SCC.
Yes, 2003 Part 8. I'm sorry, page 399. Page 399. I'm sorry, 399. But I'm sorry, I gave the wrong number. 399. Javed and others was the state of Haryana and others. 2003 Part SCC, page 369. This was a case, a very interesting fact.
200.
The Haryana government,
400.
Javed and others comes in page 400. Javed and others.
2003 8 SCC 369.
Yes, ma'am. Yes, that is 400, not lordship's judgment. What is the pagination lordship's having? So that all other numbers will change.
400.
40. Yes. Then what the paragraph page which I would show before a lordship will be 420. Paragraph 45. I will just background words.
22.
Para 45. So Haryana legislature brought a legislation to preventing persons from disqualifying them from contesting election if they are married more than once. Sorry, Javed Murad said that no, Islam permits us to marry more than once. Therefore, this disqualification infringes upon Article 25. Kindly see Murad 45.
Meaning of religion.
Yes. The meaning of religion, the term as employed in Article 25, and the nature of protection conferred by Article 25 stands settled by the pronouncement of the Constitution bench in Ismail Faraki, Dr. Wasim. That is not Babri Masjid case. I'll just refer it later. The protection under Article 25 and 26 of the Constitution is with respect to religious practice, which forms an essential and integral part of the religion. A practice may be religious practice, but not an essential and integral part of practice of that religion. The latter is not protected by Article 25. Yes. But the judgment notes, which according to me completely settles the issue and gives clarity, is in what is known as Ananda Marga case, Avaduta's case.
2004.
2004. Wherein they said Tandava dance belonging to Ananda Margis, said part of Article 25. While dealing with that, kindly see how their lordships have dealt with it. Pagination must have changed. Page 440. Mine is 4. Paragraph 9. This is quoted with approval by the paragraph 9 lordship. Yeah. Approval in the Shabarimala. The protection guaranteed, lordships get it, should I read it? The protection guaranteed under Article 25 and 26 of the Constitution is confined to matters of doctrine or belief.
Not confined to.
Is not confined to matters of doctrine or belief, but extends to acts done in pursuance of religion, and therefore contains a guarantee for rituals, observance, ceremonies, and modes of worship which are essential or integral part of religion. What constitutes an integral or essential part of religion has to be determined with reference to its doctrines, practices, tenets, historical background, etc. of the given religion. See generally the constitution bench decisions in Shirur Mat, Saidana Tahaffuz-e-Islam Sahib, Sheshamal versus State of PL. Regarding those aspects that are to be looked into as to determine whether a part or practice is essential or not. What is meant by an essential part or practices of religion is now the matter of elucidation. Essential part of a religion means the core beliefs upon which a religion is founded. This is first thing. Essential practice means those practices that are fundamental to follow a religious belief. It is upon the cornerstone of essential parts or practices that the superstructure of a religion is built, without which a religion will be no religion. Test to determine whether a part or practice is essential to a religion is to find out whether the nature of the religion will be changed without that part or practice. If the taking away of that part or practice would result in a fundamental change in the character of that religion or in its belief, then such part could be treated as an essential or integral part. There cannot be additions or subtractions to such part because it is the very essence of that religion, and alterations will change its fundamental character. It is such permanent essential parts which are protected by the Constitution. Nobody can say that an essential part or practice of one's religion has changed from a particular date or by an event. Such alterable parts or practices are definitely not the core of religion, whereupon the belief is based and religion is founded upon. They could only be treated as mere embellishments to the essential parts of practice.
Now apply this principle to.
I will obviously, I'll come to that. There's one other judgment I want to show, and then we'll apply. That is the endeavor and for 3 tests from this, Lord's test is that the core belief on which the religion is built upon, founded, number 1. Number 2, is this practice fundamental to that religion? Number 3, Lords, whether if that practice is not followed, the religion will vanish.
Change the color of the religion.
But in practically they say it will cease to be. And lastly, they say you cannot say from which date it started. The reason is Murad, it should precede the religion itself. Therefore, they say the foundation of. I was reading words not to rely upon. For instance, but 2 instances, I will come to Hijab. Venkata Swami Devaru's case. So interesting, this morning I was reading. But there was a community belonging to Gauda Saraswat Brahmins. Build a temple in district of Mangalore again. Madanapur Mulki temple. And then they say that only Gauda Saraswat Brahmins should be allowed to perform the pujas, etc. So the question is whether this forms the core. The pleading there was, see the idols, we are all who came from Kashmir, then went to Bihar, and then finally they traced their lineage, and they said these idols, which are fundamental to us, Gauda Saraswat Brahmins, was brought and given to us by our forefathers. We have established this temple. If we do not perform, if we alone do not perform the puja of these idols, the very concept of Gauda Saraswat Brahmins goes away. That is how the argument. But in fact, the Honorable Supreme Court, in that case, made a distinction. Though they said that the entry of non-Gauda Saraswat Brahmins cannot be disallowed, but the right to perform a puja will vest with them, because that forms the core belief that the carrying of temples from Kashmir, getting it through these things, preserving it, the method of puja is something which is preceded the foundation of the Gauda Saraswat Brahmin philosophy itself. That's how, as an instance, we could see. Of course, even in Shabarimala, I will bring to Lordship's notice how the arguments were advanced.
Performance of puja is not an essential part of religious practice.
It is. In some instances, certainly, it is certain.
It has been held in some judgment. I will find out.
No, in this context, in this context,
it has been categorically held.
Yes.
That performance of puja cannot be treated to be essential religious practice.
I was what happened in this Venkateswamy Deva's case was not performing of the puja. What they said, performance of the puja by the persons who belong to that particular lineage. And it was not performance of puja alone, performance of puja in the sanctum sanctorium by that section, particular section. And that has been, but ultimately the Honorable Supreme Court upheld that. It's not a mere right of performing.
Honorable Chief Justice is saying is, it's a case which arose from Tamil Nadu and Kerala,
yes,
where particular community said it's our prerogative,
our prerogative to perform puja.
Justice Nariman said it is not.
So that I'm out. Yes.
Whosoever knows Agama Shastra,
This is what has been held.
Yes. This was not the core belief theory which was expounded in Venkateswamy. But then let's also kindly see the next in the context of hijab. In the context of hijab, I wanted to bring to Lordship's notice. There's one word I will say indication with the Honorable Supreme Court as to why food and dress should not be considered as part of essential. The learned friend words Kamath Council brought read before your Lordships a paragraph in Shirur Mutt's case. Not kindly see where there is a reference to food and dress. But how that differs, what I will show before. But first, kindly see Shirur Mutt's case, paragraph 70. What was read before your Lordships?
Justice B.K. Mukherjee's.
Yeah, that was in the context of what is religious, not essential part. Kindly see para 17 of that text.
Where we will find
First volume.
This is in volume number 1, volume 1.
volume page.
Page 28. Page 28, not paragraph 70. What's that? Paragraph 17. There's only 2 sentences I want to read that and show the distinction in this case. Volume 1.
Para 28.
17, 17, page 20. The last sentence in that page. One sentence. This is what read out by the other side before your Lordship to suggest and indicate that dress also can be considered part of essential. 28, last sentence. A religion may not only lay down. What's it? Get it so that can I read it?
Para 70.
17.
How many lines?
It starts now, it will be seen that besides the right to.
Yes, yes.
Yes. In that last sentence of that paragraph, Lordships need not read the entire thing, not be relevant. Religion may not only lay down a code of ethical rules for its followers to accept. It might prescribe rituals and observances, ceremonies and modes of worship, which are regarded as an integral parts of religion. And these forms and observances might extend even to matters of food and dress. But when they read it out, the emphasis was look at this. Supreme Court says even food and dress can be considered part of the religion. Hijab is also dress, kindly considered. But now see, but the other judgment which clarifies this position. Dikshit. That is what volume 2 of that compilation. I'm sorry, I'm referring lordships repeatedly to different volumes.
Yes, yes,
Lordships may pardon us.
no problem, no problem.
Yes. In this judgment, what which commences from which?
We have volume and voluminous work also.
It has been a learning exercise, I must say. The judgment starts from page 307. The relevant portion is at 86. 86 at page 350.
Yes, name of Dikshit.
Yes, Narayana Dikshitulu versus State of AP.
Yes. Page?
353.
Yes.
In that, lordships will get paragraph 86.
Yes.
A religion undoubtedly has its basis. The system of beliefs and doctrines which are regarded by those who profess religion to be conducive to their spiritual well-being. A religion is not merely an opinion, doctrine, or belief. It has outward expression acts as well. It is not every aspect of religion that has been safeguarded by Article 25 and 26, nor has the Constitution provided that every religious activity cannot be interfered. Religion, therefore, cannot be construed in the context of Article 25 and 26 in strict and etymological sense. Every religion must believe in a conscience and ethical and moral precepts. Therefore, whatever binds a man to his own conscience and whatever moral or ethical principles regulate the lives of men believing in the theistic conscience or religious belief, that alone can constitute religion as understood in the Constitution, which fosters feeling of brotherhood, amity, fraternity, and equality of all persons, which find their foothold in secular aspect of the Constitution. Secular activities and aspects do not constitute religion, which brings under its own cloak every human activity. Now kindly see this sentence. There is nothing which a man can do, whether in the way of wearing clothes or food or drink, which is not considered a religious activity. Every mundane or human activity was not intended to be protected by the Constitution under the guise of religion. The approach to construe the protection of religion or matters of religion or religious practices guaranteed by Article 25 and 26 must be viewed with pragmatism, since by the very nature of things, it would be extremely difficult, if not impossible, to define the expression religion or matters of religion or religious belief or practice. But I only wanted to read this paragraph, though their lordships do not declare it so much, but they do not immediately after saying the word, it is possible that wearing of a dress or a hood may be part of religious activity. But it is not every such activity which can be declared part of essential practice of religion. The court must take a pragmatic approach in this issue and leave it, of course, not to the every court. But this I wanted to specifically bring to lordship's notice, because Shirur Mutt's paragraph was read as if that dress and food automatically qualify as a religious activity. Now, let's say the last judgment in this series is what, which I will say.
Read 87 paragraph after the have come to 594. The Honorable Chief Justice was mentioning other day. You will find that there.
Yes, yes.
Same judgment.
Same judgment which I just read.
80.
This is far from saying that it is not possible to state with reasonable certainty the limits within which the Constitution conferred a right to profess religion. Therefore, the right to religion guaranteed under Article 25 or 26 is not an absolute or unfettered right to propagating religion, which is subject to legislation by the state, limiting or regulating any activity, economic, financial, political, or secular, which are associated with religious belief, faith, practice, or custom. They are subject to reform on social welfare by appropriate legislation, or as much as part of religious as faith or belief in a particular doctrine that by itself is not conclusive or decisive. What are essential parts of religion or religious belief or matters of religion and religious practice is essentially a question of fact to be considered in the context in which the question has arisen, and the evidence, factual or legislative or historic, presented in that context is required to be considered and a decision.
88.
A decision reached. The court, therefore, while interpreting Article 25 and 26, strikes a careful balance between the freedom of the individual or the group in regard to religion, matters of religion, religious belief, faith or worship, religious practice or custom, which are essential and integral part, and those which are not essential and integral, and the need for the state to regulate or control in the interest of the community. Should I read 89? Should I read 89? Right, sir. This is the context in which a group of individuals, competing rights and balance to be struck.
$90.
90, yes. The religious freedom guaranteed by Article 25 and 26, therefore, is intended to be a guide to a community life and ordain every religion to act according to its cultural and social demands to establish an egalitarian social order. Article 25 and 26, therefore, strike a balance between the rigidity of right to religious belief and faith and their intrinsic restrictions in matter of religion, religious beliefs and religious practices, and guaranteed freedom of conscience to his commune with his cosmos, creator, and realize his spiritual self. Sometimes practices, religious or secular, are inextricably mixed up. This is more particularly so in regard to Hindu religion, because under the provisions of the ancient Smriti, human actions from birth to death and most of the individual actions from day to day are regarded as religious in character in one facet or the other. They sometimes claim the religious system or sanctuary and to seek the cloak of constitutional protection guaranteed by Article 25 and 26. One hinges upon constitutional religious model and another diametrically more on traditional point of view. The legitimacy of two categories is regarded to be judged strictly within the parameters of the right of the individual and the legitimacy of the state for social progress, well-being and reforms, social intensification and national unity. Law is a social engineering and an instrument of social change, evolved by a gradual and continuous process, as Benjamin Cardozo has put it in his judicial process. Life is not a logic but experience. History and customs, utility and the accepted standards of right of conduct are the forms which singly or in combination shall be the progress of law. Which of these forces shall dominate in any case depends largely upon the comparative importance or value of the social interest that will thereby impair. There shall be symmetrical development with history or custom. When history or custom has been motive for force or the chief one in its giving shape to the existing rules and with logic or philosophy, when the motive power has been theirs. One must get the knowledge just as the legislature gets it from experience and study and reflection and proof from life itself. All secular activities which may be associated with religion but which do not relate or constitute an essential part of religion may be ascertained primarily from the doctrines of that religion itself, according to its tenets, historical background and change in evolved process, etc. The concept of essentiality is not itself a determinative factor. It is one of the circumstances to be considered in judging whether the particular matters of religion or religious practices of belief are an integral part of the religion. It must be decided whether the practices or matters are considered integral by the community itself. Though not conclusive, it is also one of the facets to be noticed. The practice in question is religious in character and whether it could be regarded as an integral part, an essential part of the religion. And if the court finds upon evidence adduced before it that it is an integral or essential part of the religion, Article 25 accords protection to it. Though the performance of certain duties is part of the religion, and the person performing duties is also part of the religion or religious faith or matters of religion, it is required to be carefully examined and considered to decide whether it is a matter of religion or a secular management by the state, whether the traditional practices are matters of religion or integral and essential part of the religion, and religious practice protected by 25-26 is the question. Whether hereditary archaka is an hereditary, the same thing.
This statement which Chief said is
$105.
that's the date.
In the temple worship, the respective deities prescribe rituals.
Yes.
This entire law relating to what is essential religious practice, what is not, how the courts have evolved, stands for consolidated way in Shabarimala's case. Lord's Chief Justice Chandrachud has dealt it at length. I will take Lord's Chief. But before that, the need for bifurcating this was first spoken by Dr. K. M. Munshi in the Constituent Assembly debates, where he says, as we progress as a free and independent nation, all our religious practice which we believe must stand divorced, curtailed for the purposes of a united nation. But kindly see, this has been quoted with approval by the Honorable Supreme Court in Shaira Banu's case. Volume 3. In fact, what's Munshi, he says we should put our foot down strongly on all religious practices which will divide the country and progress as a united country by narrowing down religious practices. That's how much he gives an indication. Calls for a uniform civil code in that paragraph. Para 216. But in that judgment, but of course, what I am reading is a dissenting judgment of Chief Justice K. But this observation cannot have any relevance in so far that is concerned. Para 216.
Yes.
216. I read that portion. The Constitution, through its preamble, fundamental rights and directive principles, created a secular state based on the principle of equality and non-discrimination, striking a balance between the rights of the individuals and the duty and commitment of the state to establish an egalitarian social order. Dr. K. Munshi contended on the floor of the Constituent Assembly that we want to divorce religion from personal law, from what may be called social relations, or from the rights of the parties as regards inheritance or succession. What have these things got to do with religion? I really fail to understand this onwards, he says. We are in a stage where we must unify and consolidate the nation by every means without interfering with religious practices. If, however, in the past, religious practices have been so construed as to cover the whole field of life, we have reached the point when we must put our foot down and say that these matters are not religion, they are purely matters of secular legislation. Religion must be restricted to spheres which legitimately appertain to religion, and the rest of life must be regulated, unified, and modified in such a manner we may evolve as early as possible as a strong and consolidated nation. But kindly read this paragraph in the context of that paragraph of Dikshitlu's judgment, where they said every aspect of human activity cannot be, though maybe religious activity, cannot be construed as essential religious activity, and a pragmatic view requires to be taken. The indication seems to be what? You involve more religious practice, it results in division, more division. That seems to be the indication, because he uses the word unity and unity of the nation can be where there is more uniformity. More towards divisions. Now let's Shabarimala judgment. Last volume 5. But Shabarimala, Lordships are aware, delivered by a bench of 5 honorable judges with separate judgments by Chief Justice Deepak Mishra, Justice Rohinton Nariman, Justice Chandrachud, and Justice Kanvilkar, and the sole dissenting judgment being of Srimati Justice Indu Malhotra. The reason why I mentioned these words, I would first read the observation of Justice Rohinton Nariman words in context of essential religious practice, and then what Justice Chandrachud. But kindly see in this judgment, paragraph 166.6, page 1628.
Again? 1628.
1628 is the page. Paragraph 176.6. Chief Justice Deepak Mishra and Justice Kanvilkar, one judgment. Justice Rohinton Nariman is the second judgment. 176.6.
The majority view.
Yes. Only dissenting views of Lordship Justice Indu Malhotra. 4 of them concur together. Strike down section 4 of the Kerala Hindu Religious Act.
It is only the essential part of religion.
Yes, on that only. It is only the essential part of religion as distinguished from secular activities. That is the subject matter of the fundamental right. Superstitious beliefs, which are extraneous, unnecessary accretions to religion, cannot be considered as essential part of religion. Matters that are essential to religious faith or belief are to be judged on evidence before a court of law, what the community professing the religion itself has to say as to the essentiality of such belief. One test that has been evolved would be to remove the particular belief stated to be essential belief from the religion. Would the religion remain the same or would it be altered? Equally, if different groups of a religion community speak with different voices on the essentiality aspect presented before the court is then to decide as to whether such matter is or is not essential. Religious activities may also be mixed up with secular activities, in which case the dominant nature of the activity test is to be applied. The court should take a common sense view and be actuated by considerations of practical necessity. One test what His Lordship says is, remove that and see whether the religion remains in the same. Now, Lords, may I draw Lordship's
Read
attention?
176.7.
Yes, 176.7. The exceptions to this individual right are public order, morality, and health. Public order is to be distinguished from law and order. Public order must affect the public at large as opposed to certain individuals.
Public disorder.
I'm sorry. Public disorder must normally use the word public order. Public disorder must affect the public at large as opposed to certain individuals. A disturbance of public order must cause a general disturbance of public tranquility. The term morality is difficult to define. For the present, suffice it to say that it refers to that which is considered abhorrent to civilized society, given the mores of the time by reason of harm caused by way inter alia of exploitation of or degradation. Health would include noise pollution and the control of disease. But this control of disease, when I read, I suddenly remembered he had delivered the judgment much before the pandemic had opened. He seems to have a prophetic statement. Control of disease he wrote even before
Good noise.
pandemic. Somehow he could foresee something like this. But the elaborate analysis is done by Justice Chandrachud. Para 256. But he actually culls out the entire law and gives out certain new nuances to this.
It also gives the light on the public disorder.
Yes, public disorder.
What amounts to public
That's true. It
disorder?
was public disorder, morality, and health. All the three of them. But what now that Lordships, what I wanted to submit to all. Article 25 has different sections. In order to come out of to establish a right under Article 25, but according to me, the tests are like this. First words, they have to prove it as a religious practice, then as an essential religious practice. Then they must show this essential religious practice does not come in conflict with public order, does not come in conflict with health, does not come in conflict with morality, and then what does not come in conflict with any other fundamental rights. Then what emerges is a concept of right to practice. But the trend of the arguments which took place before your Lordships, with great respect, I must say, but they traveled the distance of essential religious practice quite quickly, I must say, and directly came to the concept of public order. That we will demonstrate. But on essential religious practice, but Lordships may kindly see how what's there on the Supreme Court views. And this is the last judgment, but it really it declares the law as it stands today. Not only that, but their Lordship Justice Chandrachud brings out the nuances of what actually is an essential religious practice. So there are some paragraphs in this judgment which repeats the judgments which I have already referred. I will jump that one. What has not been referred to Lordships earlier will be read out at paragraph 256. 1661, page number 1661. Para 256. To page 1661. What relevant? Paragraph 256. The discussion on public order by the petitioners must have been preceded by this discussion, is what I honestly felt. 256 more paragraph.
The same judgment.
Same judgment. Same judgment.
The doctrine of essential.
Yes, essential. Same judgment that is by Justice Chandrachud. Lordship Justice Chandrachud's judgment separately. The doctrine of essential religious practices was first articulated in 1954 in Shirur Math, I will say Shirur Math. A seven-judge bench of this court considered a challenge to the Madras Hindu Religious and Charitable Endowments Act 1951, which empowered a statutory commissioner to frame and settle a scheme if they had reason to believe that the religious institution was mismanaging funds. The petitioner, the Mathadipati, superior of the Shirur Math monastery, claimed that the law interfered with his right to manage the religious affairs of the monastery and therefore violated 26B of the Constitution. B.K. Mukherjee, writing for the court, noted that Article 26B allowed a religious domination to manage its own affairs in matters of religion and framed a question on the ambit of matters of religion. The language undoubtedly suggests that there could be other affairs of religious domination or a section thereof which are not matters of religion and to which the guarantee given by the clause would not apply. The question is, where is the line to be drawn between what are matters of religion and what are not? The court cited with approval the judgment of the High Court of Australia in the Adelaide Company of Jaws Witness versus Commonwealth, which held that the Constitution protected not only liberty of opinion, but also acts done in pursuance of religious belief as part of religion. The court noted the importance of both religious belief and the practice that stems from it and provided an expansive definition of religion. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine or a belief. The guarantee under our Constitution not only protects the freedom of religious opinion, but it also acts done in pursuance of a religion. And this is made clear by the use of the expression practice of religion. That is, practice of religion, acts done pursuant to a religion. That is how the lordships understand. Drawing a distinction between religious and secular practices, the court held what constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrines of that religion itself. But this sentence, lordships may kindly see how Justice Chandrachud will later on distinguishes. If the tenets of any religious sect of Hindus prescribe that offerings of food should be given to idol at particular hours of the day, all this should be regarded as parts of religion, and the mere fact that they involve expenditure of money or employment of priests and servants or the use of marketable commodities would not make them secular activities partaking of a commercial or economic character. All of them are religious practices and should be regarded as matters of religion within the meaning of Article 26B. The court in Shirur Math case ruled that the freedom of religion guaranteed by the Constitution applied to freedom of both religious belief and practice. To distinguish between the religious and secular, the court looked to the religion itself and noted that the views of adherents were crucial to the analysis of what constituted essential aspects of religion. This approach was followed in Ratilal Pannachand Gandhi versus State of Bombay, where a constitution bench of this court considered the constitutionality of the Bombay Public Trust Act 1950. The act sought to regulate and make provisions for the administration of public and religious trusts in the state of Bombay. The petitioners challenged the validity of the act on the grounds that it interfered with their freedom of conscience, their right to freely profess, practice, and propagate their religion, and their right to manage their religious affairs under Article 25 and 26 of the Constitution. B.K. Mukherjee, for speaking for a constitution bench of this court, expanded upon the meaning of scope of Article 25. Subject to the restrictions which this article imposes, every person has a fundamental right under our Constitution not merely to entertain such religious beliefs as may be approved of by his judgment or conscience, but to exhibit his belief and ideas in such overt acts as are enjoined or sanctioned by his religion, and further to propagate his religious views for the edification of others. Speaking with reference to Article 26, Mukherjee reiterated the broad view taken by this court in Shirur Math case that religious denominations had complete autonomy to decide what religious practices were essential for them. Religious practices or performance of acts in pursuance of religious beliefs are as much a part of religion as faith or belief in particular doctrines. No outside authority has any right to say that these are not essential parts of religion, and it is not open to a secular authority of the state to restrict or prohibit them in any manner they like under the guise of administering the trust estate. The court, however, recognized the limited role of the court in the determination of such a question. The distinction between matters of religion and those of secular administration of religious practices may at times appear to be a thin one. But in case of doubt, the court should take a common sense view and be actuated by consideration of practical necessity. Their lordships are quoting Ratilal Panachand Gandhi versus State of India. But kindly see now para 263 onwards. The late 1950s witnessed two cases that were crucial to the evolution of the essential practices doctrine. Now, my lord, there is a shift in the judgment of Sabrimala. Because after quoting Shirur Ratilal Gandhi, where they restrict that court has a limited role, only confine these things to the judgment of that religion. Now, kindly see, in Venkataramana Devaru versus State of Mysore, a constitution bench of this court considered the constitutionality of the Madras Temple Entry Authorization Act 47, which sought to reform the practice of religious exclusion of Dalits from a denominational temple founded by the Gauda Saraswat Brahmins. This is the judgment I was citing earlier. The court accepted the claim that the temple was a denominational temple founded for the benefit of the Gauda Saraswats and proceeded to examine whether, exercising the right of religious denomination under Article 26A, they were entitled to exclude other communities from entering into it for worship on the ground that it is a matter of religion. Rather than allowing the religious domination complete autonomy in the matter of deciding as to what rites and ceremonies are essential, the court examined scripture and precedent to determine whether the exclusion of a person from entering into a temple for worship was a matter of religion under Hindu ceremonial law. Venkatramaya revived ancient literature, practice of Hindus, and the role of temples in that practice and concluded on behalf of the court. Thus, under the ceremonial law pertaining to temples who are entitled to enter them for worship and where they are entitled to stand and worship and how the worship is conducted are all matters of religion. This firmly established the court's role in determining what constituted essential religious practice. However, the matter did not end here. The Gauda Saraswats claimed their right to manage their own religious affairs under Article 26B, whereas the state claimed that it had a constitutional mandate to throw open Hindu temples to all classes and sections of Hindus under Article 25(2)B. Noting that the two are apparently in conflict, the court considered whether the right of religious domination to manage its own affairs in matters of religion guaranteed under Article 26B was subject and could be controlled by a law protected by Article 25(2)B, throwing open a Hindu public temple to all classes and sections of Hindus. But may I request Lordships, I don't think, I want to draw Lordships' attention to para 266, which according to me, 266 and 267, which is what we want to emphasize on. 266, what may I? This case marked, do I get Lordships' attention to 266?
Yes.
This is how this case marked a nuance of the essential practices doctrine laid down in Shirur Mutt, where a denomination was granted complete autonomy to determine which practices it considered to be essential. In Shirur Mutt, the autonomy to decide what is essential to religion was coupled with the definition of religion itself, which was to comprehend belief and practice. In Devaru, that is Venkataramana Devaru, the court laid down a crucial precedent in carving out its role, that is court's role, in examining the essentiality of such practice, while the court would take into consideration the views of a religious community in determining whether a practice qualified as essential, that would not be determinative. But this is so critical not for the entire discourse case before your Lordship. The earlier shift of focus is, it is not necessary that whatever that religious denomination says, that may be considered, but the court's role becomes very, very critical. And 267, what kindly see, the way his lordship has evolved the principle. Prior to Devaru, this court used the word essential to distinguish between religious and secular practices in order to circumscribe the extent of state intervention in religious matters. The shift in judicial approach, or kindly look at this sentence, the shift in judicial approach took place when essentially religious as distinct from the secular became conflated with essential to religion. The court's inquiry into essentiality of the practice in question represented a shift in the test, which now enjoined upon the court the duty to decide which religious practices would be afforded constitutional protection based on the determination of what constitutes an essential religious practice. But if Lordships permit me to say that whenever the history of the Supreme Court will be written, according to this paragraph 267, will have its prominence in golden letters for this reason. But the way his Lordship has evolved the principle, the Supreme Court, where they say, earlier the shift was what is essentially religious, to distinguish between a secular practice and a religious practice. You apply the tests to see if it is essentially religious, it gets the protection of Article 25. The shift, he says, post Venkatramana Deva, a number of judgments. It is not just that. Even if it is essentially religious, you have to establish that it is essential to religion. That is the distinction. If they show before your Lordships wearing of hijab is essential to Islamic law, but they pass through the test, then of course public order they are stopped there. But if it is not shown that it is not essential to religion, the matter stops there, the inquiry stops. And this is how their Lordships have, according to me, evolved this principle. Lord's para Home Lords in 1962, Ajmer case, their Lordships used the word essential religious practice. Shurur Mat case also said essential religious practice. They said the test was done in order to distinguish between a secular practice and a religious practice. If it is essentially religious practice, then you get the protection of 25. And of course, Avadhuta test, that these tests is T8, but I do not want to read it in this context because there it is a Hanif Qureshi. I want to read it later. Cow slaughter, where they said sacrifice is considered part of essential religious practice. But how their Lordships have dealt with it, I want to read Qureshi's judgment separately itself. Because in this context of ERPs, 270 may be relevant.
Yes.
Their Lordships, Court Justice Gajendra Kadkar would say, our note of caution has been added. Same thing, I have read it before your Lordships. Dargah's case, Ajmer Dargah's case. $270, that's one. 270. But kindly in 270, after quoting Gajendra Gadkar and Dargah Committee's case, which I have read before, that is Ajmer case, kindly see the analysis of the Supreme Court of Dargah case, not in that paragraph itself, starting from the sentence, this statement pushed the essential religious practice doctrine in a new direction. The court distinguished for the first time between superstitious beliefs and a religious practice, apart from engaging in a judicial inquiry to determine the practice claimed to be essential was in fact grounded in religious scriptures, beliefs, and tenets. The court would carefully scrutinize that the practice claiming constitutional protection does not claim superstition as its base. This was considered a necessary safeguard to ensure that superstitious beliefs would not be afforded constitutional protection in the garb of an essential religious practice. The court also emphasized that purely secular matters close to religious form do not enjoy protection as an essential part of religion. This is more, they have quoted, analyzed Dargah case. Then Lord, the next case is that Bohra community excommunication case. Which the petitioner council relied upon.
Which they have struck down that particular act.
The act, there, section 4 barred them from excommunication. They said part of it, but kindly see what Justice Chandrachud says in that 272, para 270. About this Bohra community case, last sentence, the decision in Saifuddin, same, is presently pending consideration for a larger. $272 last, Saifuddin case. This Saifuddin case, but the petitioners were advanced, had relied upon that. $285. But at paragraph 273 note, again Dargah committee is referred to. 279 Adityanath versus Travancore, there was some vote, same principle. What I want to read in this para 280, the Avadhuta test has been explained. 280. Another market case.
Tandava dance matter.
Tandava dance, yes. Where they claim that it is part fundamental character, which was negative. The question of the essential religious nature of the Tandava dance was considered again in 2004 in Commissioner of Police versus Acharya Jagadishwarananda Avadhuta. After Avadhuta 1, the religious book of the Ananda Margis, Karya Karya, was revised to prescribe Ananda Tandava as an essential religious practice. Laying emphasis on the essential nature of the practice, claimed the majority in a 2-1 split verdict held that practice must be of such a nature that its absence would result in fundamental change in the character of that religion. And again, para 9 is good. I do not want to read that. But kindly see analysis of Justice Chandrachud of this paragraph. Essential part of a religion means the core beliefs, so and so on. Next sentence. Essentiality test came to be linked to the fundamental character of the religion. If the abrogation of a practice does not change the fundamental nature of the religion, the practice itself is not essential. Rejecting the claim of Ananda Margis, the majority held that Ananda Margi order was in existence even without the practice of the Tandava dance, and such practice would not constitute the core of the religion. Further, religious groups could not be permitted to alter the religious doctrine to recognize certain religious practice in order to afford them constitutional protection. Notes at the paragraph, but I will only reading notes. I do not want to take lots.
Yes.
Yes, 200 and notes 80 after Ananda Margam, 282 relates to Shahira Banu words. Triple Talaq considered as religion rejected by the Supreme Court words. Chief Justice Kehar dissenting. 282, 283, 284 is on Shahira Banu words. I will read Shahira Banu independently, therefore I do not want Lordships to. Can I read 284? Same thing, Shaira wants. But what is important is 285. Can I? Conclusion of the Honorable Supreme Court on these things. In its jurisprudence on religious freedom, this court has evolved. This is the summing up of the entire case law. This is the last of the decisions. So this can be taken as the law of the land as it stands today. In its jurisprudence on religious freedom, the court has evolved a body of principles which define the freedom of religion under Article 25 and 26 to practices essential to the religion. The Constitution has been held to protect not only freedom of religious beliefs, but acts done in pursuance of those beliefs. While the views of religious denominations are to be taken into consideration in determining whether a practice is essential, those views are not determinative of its essentiality. Number one, the court, this is sentence is also, the court has assumed a central role in determining what is or is not essential to religious belief. Intrinsic to the role which the court has carved out, it has sought to distinguish between what is religious and what is a secular practice. Even if it is associated with a religious activity, going further, the court has inquired into whether a practice is essential to religion. Essentiality of the practice would, as the court has held, depends on whether the fundamental character of a religion would be altered if it were not observed. Above all, there is an emphasis on constitutional legitimacy, which underscores the need to preserve the basic constitutional values associated with the dignity of the individual. The ephemeral distinction between religion and superstition becomes more coherent in terms of the need to preserve the fundamental constitutional values associated with human liberty. In determining the essentiality of a practice, it is crucial to consider whether the practice is prescribed to be of an obligatory nature within that religion. But this is also very important. If a practice is optional, it has been held that it cannot be said to be essential to religion. A practice claimed to be essential must be such that the nature of the religion would be altered in the absence of that practice. If there is a fundamental change in the character of the religion, only then can a practice be claimed to be essential part of that religion. But from a reading of these things, I will not carve out 4 or 5 principles to be applied for the present case. Number one, the practice should be fundamental to that religion. Number two, if that practice is not observed or discontinued or not followed, it would result in change of the religion itself. Second test. The third test, very important according to me, is this practice must precede the birth of the religion itself. I am very carefully stating this word because of the sentence. The foundation of the religion must be based on that. That is how their lordships evolve that principle. It is not that the practice should evolve after the religion comes. Therefore, they say nobody can come and say which practice started from a particular day. That would not form essential part of the religion. Either the practice must precede or must simultaneously be there along with the birth of the religion itself. There must be so much coextensive with that religion. This is not this submission of mine, of course, not Lordship may test me, but it is based on the context of the word core belief. The they use the word cornerstone of the religion must be there. The cornerstone, what as I've understood, is the foundation stone.
It must be part of the cornerstone of that religion.
Of the religion. And the last one, what very interestingly is binding nature of the religion. If it is optional, then it is not essential. If wearing of something is optional, if somebody doesn't wear it and it's still permitted, then it is optional. It is not binding. It must be so compelling, that if you disobey, you cease to be part of that religion. These words, according to me, are the principles which can be called out.
Only 4 you have noted.
I have said essentiality, fundamentally in nature. If not, second one, if not followed, the religion will change. Third one, words, it is not every activity associated with religion which can be characterized as religion, which includes dress and food. Lordship may kindly Dikshital food. And fifth one, words is it should precede or be coextensive with that religion. Sixth words is binding nature of that. Now, Lords, with all humility, I want to submit before your Lordships. When they argued, Lords, before your Lordships on this question of essentiality test, not only for them, for us also, the opening should have been paragraph 285 of Lord's Shabarimala case, which is the foundation of the entire case between our petitioners and the respondent. Is that what is the foundation? Unless this is delineated, the question of declaring Lords any religious practice as an essential religious practice does not arise. Now, Lords, with this background, Lordships may examine the claim of the petitioners. But I will caution myself with this sentence. But this is not a case where Lords, few followers, let us say, of Ananda Margis came before the court and asked for essential practice, a substance, or Shabarimala devotees. This is a case, Lords, where it is not petitioners alone who have come before a Lord. They are seeking for declaration of a particular dress format to become part of religious sanction so as to bind every woman who follows Islamic religion. That is the seriousness of the claim. Every woman who follows Islamic faith is required to wear the hijab as per the religious sanction is a claim made by them by way of a relief. But kindly see the pleadings which have been placed before your Lordship in this background. But I wanted to open the submission by saying, if somebody has come before the court, in this case, particularly of such, the burden is entirely upon them. The burden rests upon them with these principles which the Honorable Supreme Court has evolved to show. Yes, this particular practice is fundamentally different. This practice, if not followed, will result in change of the character of the religion itself. If this practice preceded the birth of religion itself, this practice is binding in nature. If you do not follow, so you cease to belong into that religion. But kindly see the pleadings in the petition. There are a number of petitions. I do not want Lordships to shift the papers. Therefore, we have made the relevant pleadings relating declaration by way of a charge. So, But there are about 8 writ petitions, and we have been very careful to go through every line of the pleadings to see what is the basis to ask for hijab to be a part of essential religious practice. Kindly see 2146/2022. What is the averment? Forget evidence. Forget the evidence. Para 22. Wearing headscarf by young girls is part and parcel of their cultural and religious practice. This is the only sentence we got to get it. WP 2880/22 para 4. Petitioner here conscientiously choose to follow the tenets of Islam, one of which is to observe hijab headscarf. Not only is it a part of their essential religious identity, but denuding them for pursuing their education unless they give up on it is also an affront to their right to living with dignity protected under Article 21 of the Constitution. 24. Petitioner's practice of wearing hijab, which according to her is an essential part of religious practice, in no way interferes with the imparting of education. Para 26. Injunction to wear a headscarf or hijab is an essential feature of Islamic practice, being ordained by the Quran itself. Para 28. They being followers of the Islamic faith since birth and is practicing an essential religious practice of wearing hijab headscarf. Para 36. Petitioners believe that it is an essential part of their faith and conscience that they must wear hijab. Para 41 verses of Holy Quran and the narration of hadiths contain the essential religious practice to be followed by persons of Islamic faith. Then writ petition 2347 of 22. Religious practice of wearing the hijab is neither entangled in public law, nor is there any conflict between petitioner's right to religious freedom. Para line 11. Thus, by keeping a check on such unfettered action on the state to deny the petitioner are guaranteed right to education merely on the ground of wearing the hijab, which is essential religious practice, would amount to reducing the rule of law. Para 16. The discussion in the aforesaid case would show that covering the head and wearing a long sleeve dress for women have been treated as an essential part of Islamic religion. In writ PIL, which has been filed, there is in the 3424 of 2022, no averments in the petition that wearing of hijab forms part of essential religion. There is no averment. In PIL WP 3821 of 2022, no averments. In WP 3853 of 2022, only one sentence. It is religious practice. In WP 3044 of 2022, covering the head and wearing a long sleeve dress. In WP so and so 3038 of 2022, it's just saying essential. But now, Lords, I am nobody to criticize, I'm nobody to say anything, but I can only say with a lot of responsibility. In a case of such kind, where you not only want to bind yourself, the petitioners, you want to bind everybody by this, and which gives rise to various sentiments, divisions, etc. You ought to have shown more circumspection and discretion in seeking declaration, particularly before a constitutional court. Law is something there, law is there for us, all of us. But foundation pleadings, so that it would have assisted your logic, it would have helped us in traversing or anything. But this material, but this test I only want, I took Lordship's valuable time to read this only to tell this, that if Lordships want to apply this test, what is the material, what is that material Lordships have to apply? That sentences, averments made by petitioners without even absolutely no material whatsoever. Therefore, what my submission is this, before I have something else to say, that the petitioners have not placed any material whatsoever, what's mechanism. Not sufficient material, but I'll say no material whatsoever. It is a zero material which has been placed. To substantiate their claim for a declaration that wearing of hijab forms part of a fundamental right to, that is to say, essential religious practice. They have quoted Quran. I will come to that. I have to say that. The Constitutional Court, which has been called upon to decide this issue, must examine this material with reference to the law which has been laid down very clearly as to how it should be declared as an essential religious practice. If Lordships venture to declare that, then Lords, and we're trying to apply those tests, Lordships will not find if they want it to be declared as 2, it is 1 plus 0, it will not deal with anything else. The result will be 1 only, Lord, it can't be 2 for any. Now, Lord, for the Quran they have quoted. I will deal with that one and I will show before you. Now, but my responsibility, I thought, doesn't end there. Because it is not the petitioner's account before here. There are several men belonging to Islamic faith, but we are responsible equally as much as they are to assist your Lordships and show whether it actually forms essential religious practice or not. Our examination shows independent of that, because they have failed to place material. According to me, our role does not end. We will make an endeavor and show before your Lordship. It does not. If it does so, I concede before your Lordship, whatever material we have. But an examination made by us independently, it does not. So that I will show. But before that, what I want to place before your Lordships, issues relating to what happened in earlier situations. Whenever different faiths, apart from the Ananda Margi's exception, whenever reliance was placed on Quran for the purposes of declaration of certain practices, essential religious practices, in at least 4 instances, the Supreme Court negatived it. How they negatived it, I'll place it. These 4 instances are like this. Number 1, in Qureshi's case, first time in 1959, I will show before that, they quoted Quran to say that sacrifice of an animal forms part of Islamic verse and therefore must be considered as an essential religious practice.